Good morning, everyone, and welcome to our final meeting of the Child Custody Court Proceedings Workgroup. This has been a challenging effort, certainly, but so important for our at-risk children and protective parents. At the beginning of this meeting, I want to especially thank Jennifer Botts, Jennifer Young, and Heather Marchioni for their hard work in pulling together all of these recommendations and helping us to formulate the recommendations and facilitating each of our work group meetings. It's really been a stellar effort on all of your parts, and I personally want to thank you for doing that and providing such great support to us. What we're going to do this morning is we're going to go through the recommendations and focusing in on the ones that we didn't finish last time in our last meeting. And our last meeting was an open meeting, so there are no minutes from that, so we don't have to deal with minutes today. So as we go through this, we're going to be working on ones that are listed as draft recommendations. And not, if it's just plain recommendation, those we've already dealt with. So let's get started then with draft recommendation 1. So there are some things that have been added here. This had to do with Senate Bill 594, which was sponsored by Senator Lee in the 2020 session, but changes to the family law that are being proposed. Are there any comments or suggestions or discussion about this first recommendation? Anyone?
Can I just get a reminder of what happened 2 weeks ago about this one? I think we just set it aside for a minute to do something, but I'm having trouble remembering what we were supposed to be thinking about. Does somebody recall?
Michael?
I can,
or Jen, yeah.
If Michael wants to take it, I can explain what I did with the recommendation.
Sure.
There seemed to be some discussion about the second part of the proposed new language, that neutral and physically present supervision. There was some discussion that, if you look at the actual statute, it talks about abuse or neglect. And we were concerned that it's really not a one size fits all kind of recommendation when we talk about what sort of supervised visitation arrangements the group would like to propose. So the sort of general language of the draft recommendation is just to articulate that we would want to perhaps break out by neglect and then by types of abuse, what type of supervised visitation arrangement would be preferable for that bill. In some cases, the neutral and physically present supervision might be appropriate. In other cases, perhaps we don't need that qualifier. So there wasn't anything else really specific developed. It was just a note that that is something that we would like to see different with the legislation.
Right.
So that we had talked about adding a sub C that set out intimate partner violence or domestic violence from child abuse, from child sex abuse, or were they combined?
Break out child sex abuse, I think.
Yeah. Yes.
Yeah.
So we didn't take the next step of putting in the specific language because we didn't get any, and we probably just don't need it at this point, but it was just to remind us that that's what the legislation would need to do, is to actually break it down a little further so that child abuse and neglect weren't lumped together. Instead, child neglect, child abuse, and then child sex abuse.
Okay,
right, and
thank you.
We're not writing the legislation here, obviously.
Right, although this is the written legislation that was Senate Bill 594. That's what I was trying to understand, what the recommendation is going to look like versus what we're reading on the screen right now. So it's different, is what Jen is saying. The recommendation reads differently than this.
Right.
Is that correct?
Correct.
Right.
The recommendation would basically be that first little paragraph. We just showed what the bill was because I'm assuming most people don't know SB 594 by heart. So
okay, thank you.
Sure.
Great. Anybody else on the recommendation, draft recommendation 1?
That's what Senator Lee was thinking as well.
Okay, great. Thank you, Michael. All right, let's move on to draft recommendation 2A. Final meeting of the Child Custody Court Proceedings Work Group. Okay. In this case, it looks like we've got definitions, specific definitions that it's not final language as has been pointed out, but this was capturing some semblance of that. And I would guess, again, these would be greater defined when going into the legislation itself.
And again, I think the intent here was so that the family law courts don't use the somewhat more criminally based or whatever definition that comes from our protective order law. Is that correct? We want to broaden the definition so it's not just that strict, you can get a protective order for A, B, or C type of behavior. Is that what the recommendation is addressing?
Yeah, so that they don't lean on the protective order, the child welfare law, and criminal law. You know, that there's a specific definition for.
Right. I think we should note that. Should we note that in there? Have a statutory provision expanding on or separate from.
That's a good point.
I would say separate from, not expanding on, because.
Right, separate from.
It could be.
Yeah, and Jen, if we could make sure that on the sexual abuse that we're including things like sometimes as part of the grooming process, offenders will engage in self-fondling, but not necessarily touching, moving over and crossing over into touching the child yet. They might start with exposing themselves in an aroused fashion. They might expose the child to child sexual abuse images or videos to reduce their inhibition and normalize sexual abuse first. And that's all part of a process that the offender uses to diminish the child's defenses and normalize it. And I think that we need to make sure that that definition of sexual abuse is all inclusive. And Claudia or Jen Shaw, if you have anything to add related to that.
So just so that people know, this definition comes from the CDC's definition of child sexual abuse, and that exposing a child to other sexual activities would include a broad array of, just the grooming behavior, all that you just talked about. I think in legislation we could definitely get more specific. I know we did in the Sesame bill and the child sexual abuse prevention legislation that was passed a few years ago. We got more detailed around grooming, what grooming behavior was.
Okay, great.
And the definitions under 5701 in the family law article are a good starting point when it comes to the drafting, and then this can gap fill to things like grooming, which I think was in the Sesame bill, but not necessarily in 5701.
Yeah, I'll just add the exposure piece. I believe that encompasses the exploitation, but what you're talking about is the voyeurism as a part of the grooming. So making it clear that watching a child unbathed, being in the bath, all those inappropriate boundaries is often is abuse of its own, because it's exploitation of a child for own sexual gain, but can also lead to the direct touching. But in and of itself, harmful and under the definition of sexual abuse. But it sounds like what you're saying, the exposing a child to other sexual activities may include that, but we can expand later with the legislation.
And that could also include showing children videos as well, things like that were, again, grooming kind of thing.
Mm-hmm.
Okay, anything? Go ahead.
I'm sorry, just to make sure I'm clear, when we move this from draft recommendation to recommendation, really we just would provide expanded definitions, since that's what we're doing. And again, the specific examples were from Claudia, but may not necessarily translate exactly over to legislation, but provide expanded definitions is sort of the intent of it. Is that accurate from everyone's point?
Any Anybody disagree with that?
Nope.
Okay. All right, then let's, that's great. Thank you, Jen. All right, we'll move on then to draft recommendation 3, which is, let's see, amending statutory law regarding acts of domestic violence in the context of child custody cases, which again includes incorporating new definitions, establishing a rebuttal presumption that custody, physical or legal, to a perpetrator of domestic violence is not in the best interest of the child. Let's see. How specify how such a presumption could be overcome, and establishing determination and actions are required when acts of domestic violence have been committed by both parties, and specify examples of permissive custody arrangements to protect victims of domestic violence. So I think you laid out here on our separate paper some of the kinds of meanings and definitions. But anybody have any additions to add or change on the recommendation 3? Okay, we'll go on then to recommendation 4. Let's see, anything to add? Nope. We don't need recommendation 4 and 5 and 6 and 7 and 8 and 9. Because those are already taken care of. So we skip on.
I just wanted to, I know we already did these, but these are just really very technical. In number 6, we did not include, we said safety risk, but we didn't include physical and psychological safety risks, which we had in most other recommendations. And then in recommendation 7, the third line
Well,
down.
let's stop on that a second. That sounds like a reasonable incorporation in 6. Does anyone have any objection?
I'm sorry if I missed that, Claudia. Physical and psychological safety risks?
Safety risks, yes.
Okay, I have track changed, added that. And
in recommendation 7, it's just a typo. The third line down, it says specially trained judges will be, not be.
Whoops.
Yeah. No biggie.
That how many times I read that and didn't catch it.
Yes.
Good catch.
This all the time.
Always takes a second set of eyes, no question. That happens to me all the time.
I'm sorry.
That's a good catch. Okay. And any others? 8, 9, let's see. Unless there's any other, go ahead.
9, same on number 16, child's physical and psychological safety.
Okay, so we're going to skip then to draft recommendation 15B.
Secretary, if you don't mind, I think it was recommendation 10 on the number of hours. I know is it 10? Yes. So I know we discussed this a little bit 2 weeks ago. I'm still feel very strongly that the 20 hours, it just stands out to me that that's incredibly, it's just not enough hours. And I feel like it just stands out to me, and I wanted to get everybody's input on that, but I think we should at least be in the 40 to 60 hour range. And the reason why, obviously I say that, these are all very complex cases, as we all know. And not only that, the judges who will do these training that would be considered special training, I really think that they would want to have the hours. If they're committed and they want to make the right choices, I don't know why that would be an issue. So I just feel like it's too low. I think we need to set a precedence of, the importance of what we're doing.
In
And
this case,
This is on
in this
9?
case,
This is on
9 or
recommendation 10.
Oh, 10 isn't the judges, though. That's
no,
interesting.
10 is the lawyers, right?
Yeah, it's the
Well-
lawyers.
Well, I think it needs to be consistent.
Yeah.
Victim
Well-
advocacy training in the state of Maryland requires 40 hours.
Right, so that would be 9 and 10 that we're talking about.
For
Yeah,
both 9 and 10.
I would concur with Ann. I think that 20 hours is too low. It looks like it's almost like a kind of a throwaway, not substantive and specialized.
I would
Okay.
agree as well. And I think it should include child custody evaluators too. So all three, the judges, attorneys, and custody evaluators.
Very good. Yep, I agree.
Okay.
So do we want to say 40 hours?
40 hours.
How does
Okay.
everyone feel about 60 hours?
I think we need to do 60 hours. And I think there's something that Jen put in there, which was great, that said if there's an additional training that, is necessary, we can do that. However, we don't know 60 hours. I'm going to stay there.
Can I ask a quick question? Who's going to be providing these trainings?
Right.
That's
my excellent question.
I think, Nina, we can get into the specifics of that in our legislative efforts. I don't know if we necessarily have to spell that out. And Jen, I will defer to you on that in terms of legislation as opposed to the recommendations.
I mean, don't the trainers have to be specialized too? Right?
Well, for it to be meaningful training, obviously they have to have the expertise that we want to pass on to these attorneys.
Sure. And I think, as a whole, as a group, I think we could all kind of come together and be more specific with that when we actually go to do or look at legislation efforts. I think that's where we need to put that in there.
Can we just add to the recommendations that the trainers have to have a specialized expertise in whatever if it's domestic violence or sexual abuse, I think sometimes I look at the AFCC trainings and I'm astonished who they have sometimes at those trainings. They, because somebody wrote a book and had an opinion, all of a sudden they're an expert on something.
Right. No, I agree. Absolutely. I mean, it's not just about the hours of training, it's who's doing the training. So I don't know, Jen, what's the appropriate?
We can certainly add in that as a recommendation, if you want the trainers to have expertise, we can specify that. And we can also, I just want to make sure we're all on board, whether we're saying 40 or 60. I think we're bouncing around to a couple of different ideas. So
Can we all agree on 60?
Is there anyone that doesn't agree on 60?
I think Delegate Atterbury has weighed in.
Yeah, and a good point in that sometimes in the legislative process there's a tendency to drop hours down. So it would might be smart to go with what we think is really required. So if it is 60, then let's go with 60.
And in context, Maryland doesn't have required continuing legal education for general lawyers like most states do. So.
Correct.
Right.
And this is a special case, so there's a good reason to.
And considering that real estate agents here in Maryland have to do at least 145 hours, I think, to actually homes.
Public defenders have to complete 12
Okay,
hours.
guys, let's go ahead, Nina.
Sorry, public defenders have to complete 12 hours of continuing legal education every year.
Okay. Well.
All right, I think we have a consensus, so let's go ahead and move along.
Okay, I'm sorry, can I just make sure? So for recommendation 9, which is judges, 10, that is the attorneys, and 14, custody evaluators, we're saying 60 hours initial training by trainers with expertise, correct?
Correct, that's my understanding.
Okay.
And then Jen, can I just talk a little bit about the training element, which might speak to the number of hours? If it's a comprehensive training program, I've talked with a few folks here. If it includes several kind of stakeholders, whether it be clinicians, and then I know child advocacy centers have data and training, SCAN. But if it's in concert with kind of the research side and the data side, and treatment providers, then actually the training elements become, it can be 40 or 60 hours if it's that comprehensive. If you're talking about what are the statistics, what are the law, and then what are the implications. So then you have a child abuse expert as well as somebody on the research side. And so then it's divided into those components to be a comprehensive program where it's 20, 20, 20 or whatever it is. Does that make sense?
Okay, I don't want to, this might open up a whole nother can here, but if we're increasing the initial hours to 60, do you still want to keep the ongoing every 2 years training to at least 10, or?
Thoughts on that?
I think we should keep that requirement in. Things change, social science gets updated. They need to remain up to date.
I would second that. Just in terms of the field of the neuroscience right now, it's exploding in terms of the long-term impact. So most fields, you have to do continuing education once a year or once every 2 years. So 10 every 2 years to catch up on the statistics, but also what's going on in neuroscience in terms of the impact of abuse makes sense to me too.
Yeah, I think we have a consensus on that. It makes good sense. Paul, did you have something else?
Oh, no, sir. I agree.
Okay. No problem. Okay. All right.
My point was, are we just making sure we still just want at least 10 and not at least more? That was more the recommendation, to make sure it was the 10 hours and not the fact that we would want ongoing training in general. It's just the specific hours was really the question there. But we will leave it at 10.
10 seems like a reasonable for an update.
Yeah.
I think is what I hear. Okay. I mean, again, that can be changed, but 10 seems like a reasonable number. Okay. All right. We'll go with that. Anything else related to that? If not, we're going to move on to draft recommendation 15A. No, 15B, I'm sorry. It says 15A on here. I thought it was 15B.
I might have changed it from 15B to 15A to keep it in line with what we did earlier.
Okay. And that's the one that says require custody evaluators conducting the evaluation. Yeah, 15A, right. That includes an acknowledgement of domestic violence and or child abuse to have experienced and current research informed knowledge that demonstrates competency or competence in specified areas.
Dr. Saunders recommended using the word disclosure in some other contexts. Do we want to consider disclosure instead of allegation here?
I like that.
Mm-hmm.
Can I just add, within the field, we often say disclosure and or discovery, because there can be a discovery of symptoms or walking in on a child or art, and it's not necessarily a verbal disclosure. When people say disclosure, they assume it's a verbal statement. So disclosure or discovery is what we use in the field.
Agreed. Thank you, Dr. Shaw. Agree with you 100%.
Mr. Secretary, could I talk?
Yes. Of course.
I want to just take a moment to acknowledge the non-members of this task force and their recommendations that they've submitted. I know that, a lot of protective parents spend time being gaslighted in the criminal justice system itself. And I want them to know that we are paying attention, we are reading everything that they're sending and taking into account the recommendations that they're making. And we appreciate their willingness to come forward and talk about something that is pretty traumatic for them as parents to go through. I want to pull out a couple of those non-member recommendations that I thought were really valid. One was not allowing a custody evaluator to be appointed during any kind of investigatory phase or adjudicatory phase. So while the court is either trying to determine whether abuse has happened or whether the police are trying to determine, or social services, that's not an appropriate place to insert a custody evaluator. Because if we're putting safety first as the priority for children in these cases, then that has to be resolved. I also want to point out there are a lot of times where there's not enough evidence to make a finding, but it doesn't mean that abuse didn't occur. So in those situations where there is no finding, post-adjudication or investigation, if the court is going to then deal with custody issues, I think it's really important that we require that custody evaluator have expertise in the type of abuse that was at issue, because sometimes children are very young. They may not disclose during a forensic interview. They may even recant. That's very common. And we don't want to insert a custody evaluator into a situation where a child's on a continuum of dealing with what's going on, and they may not be ready to fully disclose or talk about it yet, or they may even be partially verbal. They may not be able to communicate what's happening explicitly in a way that the court can land on a finding. So I'm hoping that we can include that around, I don't know where, Jen, I don't know where the appropriate place would be to put those two recommendations, but I do believe that those recommendations are very valid.
Well, you make a very compelling case, and I'm glad you brought up, I was intending at our close to again thank those that have been participating from the outside in, and it's really been very, very helpful, I know, for many of us. So I'm glad you paid tribute to it at this point, and it's a good point. Jen, do you have some reaction to what we've just been discussing that you need for clarification to incorporate those points?
Maybe, Camille, if you could just sort of think of a 1 or 2 sentence way to give me, that way we could read it out loud. It could be at the end, just to make sure that we're all in agreement. It's sometimes a little hard. I think I may understand a point someone's made, but then, we're not having another meeting. So I want to make sure that I'm getting it exactly. So okay, perhaps if you could just think of a sentence or two, and then we could read it aloud and make sure everyone's in agreement.
Okay.
That'd be great. Maybe even if you can text that as well along the line.
And I'll just say, I think as to the point about having specific expertise, that is what 15A is getting at. And if you'll notice there at the examples, just for Camille's point, to make sure everyone else saw it, that we did indicate that further requirements specific to different types of abuse can be added. So we already kind of had our eye on that, but Camille will certainly come back to what you're developing now. Thank you.
Great. Okay, anyone else on that? Is there anything
Well, this
else
might be part of what Claudia was saying. I just wanted to add
Right.
that if it's specific expertise, and in 15A, is it possible then, as part of the core training, that training include, basically statistics and prevalence, right? And just the current data on the amount of child abuse cases. And if we have that, it informs kind of this need to consider false reporting as exceptional, right? So if you have the statistics and the large scale, plus the potential impact of it, that data in and of itself will inform a child-focused plan. So if even adding that as a training element, statistics and prevalence of child abuse, so there's always a current understanding of the scope of the problem and the impact.
Point. All right, anyone else? Okay, we'll come back to that. The next is draft recommendation 17. Let's see. Any questions or comments or discussion of this? Since this is implementing some of the draft recommendations of 15A.
Correct.
Okay, seeing none, we'll move ahead. Let's go to draft recommendation 19. talking about uniform requirements for what custody evaluators are supposed to be doing.
So in number 2, one thing that I would add, when it says among other items, in number 2, it doesn't specifically say, or to, it says specifically caregivers who have access to an opportunity to observe a child, but not that, or to whom a disclosure or has been made. So, I mean, I think that can be a separate thing than observing. And I think it's important that if a child's made a disclosure to someone, that person is interviewed.
Okay, so that sounds like a separate one, right?
Well, it could be included into.
I think we could, after specifically, we could say specifically number 1, the language that we have now, and then again, this is really just examples. Okay. And then number 2, individuals to whom a disclosure has been made. Claudia, with that?
Yeah.
Yeah, as long as we get in about the disclosure part, that makes sense.
Disclosure. Okay.
Okay. Any other points on 19? Okay.
So I'm sorry, Secretary. So this is Ann. I'm just trying to, and I can't see a part of this as we're reading number 2 that Claudia addressed. I'm just, when we talk about relevant disclosures from someone, obviously a lot of the times it's disclosed to the protective parent. So is that something we should kind of point out in this? And I apologize, I can't see to the right of my screen, but obviously we know as people working with these children, and we know that they disclose to a parent some of the times, or a lot of the times, and it's not taken in consideration. So I'm just wondering how we can fit that in. Do you have any thoughts on that, Claudia or Dr. Shaw? Or Camille, anybody?
I do. I get, this comes up a lot, Anne, is the protective parent is often the one with the most information. I mean, it's daily functioning, daily behavior. And so if you're looking at the mental health status of a child, you're going to first start with who's with the child every day. And if that happens to be the protective parent, we can't dismiss what they say because there might be an assumption that they have another motive. So that's where it gets complicated in cases that I have, is so can we put in there with, there's a prioritization of the one with the most most time with the child, or most able to provide, daily functioning, so that regardless of what's going on in court, a child-focused way to look at it is who can tell me how the child's doing today and this week, and that be the most relevant source of information.
Yeah. And not to discredit that, put that in with,
Because a lot of custody evaluators will talk to a lot of people, but it's not clear if they're giving weight to the person that can look at how did the child sleep that day? What did they eat that day? Are they having nightmares? It's as if they have equal input.
Right. The protective parent is a relative, source.
Yeah, it's the primary source of information because it's the primary caregiver with daily access.
Exactly. So I think that really needs to be in there as a part of that.
Jen, do you need some specifics on that, Jen, or what's your thoughts?
Do you want just to say specifically caregivers, or they're just saying specifically, I feel like caregivers is maybe already encompassing the protective parents, where I think of caregivers, but we could just put including or especially protective parents, or is that the language you're going for there?
I'm going to defer to Dr. Shaw on that.
Yeah, I think when I was looking at this, the last time we talked, caregivers assuming it's read as the primary would have the most input, but that's not always the case. So I think what we're talking about here is really spelling it out, where specifically caregivers who have access to an opportunity. So that sentence, and maybe just a qualifier, with the most attention to the parent or caregiver spending the most time with the child, whatever that language is, but making it, qualifying it, that the priority is who can tell me how this child's doing today and this week, not how this child did every other weekend. If it's going to be data from the child, it's going to be who observes the child on a regular basis. So maybe it's prioritizing those who can provide regular input on the child's functioning.
So like with particular emphasis on the caregiver who has spent the most time with the child.
Yes, because a lot of people will say relevant sources of information. They talk to a teacher or a babysitter, and if the protective parent is the one making the allegation, it's as if their input is just as important or less so than other people involved.
Okay.
All right, we good?
I think I've got that.
Okay, great, Jen, thank you. Anyone else on that recommendation? Okay, we're making pretty good progress here. Our next one is draft recommendation 20, having to do with record keeping requirements. Any discussion, thoughts on that? That seems pretty straightforward. Okay, seeing no further comments on that, we'll move along to draft recommendation 21. And this really goes to the point of the need for the safety of the child. I think is clearly one of the messages that coming out of this.
I would say for 21, it has the word allegation, and if we were going to change that to disclosure or discovery.
That makes sense. Anyone object to that?
Nope.
Okay.
Joyce, can you just do it one more for me? I'm sorry, I'm trying to type it as you go.
I'm sorry. Did you want me to repeat that or type it?
Oh, just repeat it for me.
Oh, take out allegation and put in disclosure and or discovery to, I think, keep it consistent with some prior language.
Excellent. Thank you very much. Sorry about that.
Okay. I think that finishes that up. So do we need to go back? We need to go back now to what, 15A?
Yes, or maybe it'll end up going somewhere else, but we have some. Camille, do you want to? I know we put it on chat, but just let's read it aloud because the public is viewing and it's an open meeting and they can't see the chat. So would you mind just reading for everyone what you typed out for me?
Okay, for the first one, the court shall not appoint a custody evaluator during any investigatory or adjudicatory phase of any case involving a disclosure or discovery of domestic violence, abuse, or child sexual abuse. Number 2, if the court is unable to determine that abuse occurred, the child's safety shall be first priority, and any post-investigatory or adjudicatory custody evaluation shall only be conducted by an evaluator with specialized training, education, and experience in the type of abuse at issue. Having conducted evaluations in cases where abuse has been alleged does not meet the required standard of specialized knowledge, education, and experience. Also, custody evaluators should not be making determinations of credibility or of abuse. This is strictly within the court's purview and authority.
Yes. I particularly like the credibility issue, which is something I always bump into in these things.
I have a question about, when custody evaluate, I hate to say it, but I think that's when courts do appoint custody evaluators, is when they have tough issues and they want more information. So I'm just not sure when there's not really a specific time that they're required to make that determination of child abuse or domestic violence or child sexual abuse initially, or have we required that? Does the law? I don't think the law requires that now at an early time in the process.
Yes, I'm sorry, I'm also not sure about number one. Can you?
If I could answer Claudia's question really quickly, at least based on my experience in child welfare and in criminal law, evaluations are not admissible in court prior to disposition. So they're not allowed at the investigatory stage. They're not allowed at the adjudication stage. They are admissible at the disposition stage when the court is determining where the child should be, in whose custody the child should be placed. And then there is case law coming out from the criminal side of things that specifically does not permit the admission of any testimony made by an evaluator about the credibility of any disclosure or allegation of child abuse or sexual abuse.
Right, and that case law applies. The case law applies on the civil side as well, although it's up to the lawyer who's opposed to it to raise the objection, because they will slide it in often, and courts will allow it unless obviously someone raises the objection. The way it works on the custody evaluations on the custody side, at least generally, or in my experience, is when they're done, they'll issue a report. And the different courts do it differently. Some require the report be filed with the court, and then it's produced to the parties. And some require that some will have it produced to the parties, who can then depose the custody evaluator, at least theoretically attack the report, etc. And then they will come and testify as to the report, and then we'll move it. Someone will move it into evidence, and then that'll be subject to objections or not. But it's not uniform throughout the state. Different courts do it differently.
So
Anything
then
else?
so that number one would be really just what the case law says right now.
Let's see.
Is that what you're saying, Nina and Paul?
I'm gonna go back to the chat. Let me see.
It's not specifically in the family law case law, but I do see that in the SINA side of things. So I think it would be good to clarify that, as Camille suggested.
Number one, I don't.
Right.
So can you scroll up a little bit?
Yeah, number one isn't actually addressed on the civil side, the custody side. Number three, which actually is a number, which just says also, that is in case law. I mean,
Could we scroll up to the next page?
Are we on the next page where it's not numbers, it's letters? That's what's confusing me.
It's the chat.
No,
I'm looking
we're
at
on the chat.
I'm looking at the
We're in the
chat.
chat.
Oh, the chat.
The
Thank
chat.
you.
Yep.
It's number one of the chat. So I mean, and I think it's also whether the court shall not appoint a custody evaluator during that time, or whether they won't use any report during that before that decision is made, or when is the decision made? That's my question.
That's my question too, is when would they appoint
Yes.
the evaluator?
Anytime.
Often it's at this, I mean, it could be, Paul, I don't know what your experience is, but what we see is custody evaluators are appointed in a family law custody case, whether there's divorce or not. It's at the scheduling order that the magistrates make that determination to appoint a custody evaluator. So it's fairly early in the court process.
Yeah.
Usually. The question is, when you have a modification or something, does it happen then? But usually, in my experience anyway, it's relatively early in the case, the court assigns a custody evaluator. So
that's mine as well. But they can do it anytime. There's no requirement. They can. A court can think it has a simple case, and then after a one or two status hearings, it realizes it's a more complicated case, and the judge then decides, I want a custody evaluator. But
Yeah, and
Mine is the
sometimes
same
that's
as- yeah.
appropriate. I mean,
Right.
that's, that's not a bad thing that they can say, wait a minute, this is way more complicated than I thought.
Mhm.
Now I want
Maybe we
custody
could just change
evaluator.
the language to say that the court shall not admit in evidence or consider the evaluation until the disposition stage, not during the investigatory or adjudication stage.
So I'll
see,
be
but they don't-
honest with you, I have trouble with that vocabulary because in civil law, we don't talk about it as adjudicatory, investigatory,
Right.
and disposition. That's
Right, I
not how
agree.
family law works. So, when I think of disposition, I'm like, that's the guilty finding by the judge. By then, in family law, if the trial happens, it all happens during the litigation that this
Right.
comes out. I'm just having trouble transferring that vocabulary to the civil arena. And so I don't, even this investigatory or adjudicatory phase, it makes no sense to me in the context of family law in Maryland. So I'm not sure what the vocabulary should be, but this doesn't comport with how we experience family law cases.
But I agree with Lori on that 100%. I've never seen those phrases used in anywhere except for SINAs.
Yeah,
Right.
I agree.
Oh.
So that's why Nana's, you're familiar with it because it's your life, but that's not my world. We never talk about, like with my staff attorneys, we never say, well, are you in the investigatory
Right.
or the adjudicatory phase? We're
Right.
like, are you going to trial? Have you had your
Right,
settlement
right.
conference
You're
yet?
trying a case, right?
It's a totally different vocabulary. So this doesn't, it's a mismatch in that
And
way.
just to extend it out, usually it's just like my investigatory would generally be considered, I think, a discovery phase on the civil
Discovery,
side.
pre-trial.
Right, pre-trial, but they don't. I mean, I have one right now. I mean, courts will set a trial date and they won't enter a discovery order at all. So you're theoretically in discovery up until the day of trial.
Right.
So I'm not even sure I would feel comfortable calling it the discovery phase because.
Is the goal to make sure the custody evaluator is not appointed until CPS has made a finding? Or is that too narrow?
That's too narrow.
Yeah.
Because
thought it was
CPS is
so
not
that-
involved in
all the
80% of our
cases.
custody
Yeah.
cases,
Right.
90% of our
point-
custody cases.
I thought the point was so that the judge, when making a determination about whether the abuse occurred or, whatever has been disclosed occurred or did not occur, that the judge would not be influenced by the custody evaluator's report. Am I completely off base?
Well, what would be the point of having one if the
Right.
judge isn't going to be influenced about it?
No, about the truth of the allegations, but that when it's time for the judge to make a decision about custody, in whose custody should this child be placed, then that's when the custody evaluator's report would be relevant and helpful.
Well, but that's not,
they
I mean,
don't-
that doesn't make any sense to me, to be honest. I mean, when you have a custody case, each side is putting on their case. It's typical American lawyer litigation and advocacy for your client's position. So if the custody evaluator's report is beneficial to my client, I want it to come in, I subpoena the preparer of the report, I do what I can to have it come in, and the other side says this is really negative for my client, I'm going to try and say it's filled with hearsay, I don't want it to come in, the court shouldn't use it, shouldn't rely on it, and it's part of and parcel of the entire litigation of the case. And I can't fathom a litigation of a custody matter where there's been a custody evaluation somewhere and we go through the entire trial and then have closing arguments and then a judge opens up the custody evaluation and reads it then, because that doesn't give the advocate, the lawyer, any chance to rebut any of that information or put on alternative evidence in the face of what are sometimes really biased, inappropriate custody evaluations. So
I hear you. Maybe Camille could explain a little bit more about the intention of number one.
Yeah, so I think that having a custody evaluator come in during any kind of investigatory or adjudicatory phase where they're still trying to determine what's happening, whether it's CPS, law enforcement, or the court, is like putting the cart before the horse. The primary concern at that point is, did abuse occur? If so, what is the appropriate safety plan for this child and his family? Not let's insert someone with no specialized knowledge about abuse, and then they come in with all of their bias and lack of experience and knowledge and expertise, and they're an additional uninformed, harmful opinion about abuse when they have no specialized training in that regard. They're just looking at best interests and friendly parent doctrines. So to insert a best interest friendly parent doctrine in the context of did abuse occur is the cart before the horse. You have to deal with the primary issue first, and that's the child's safety. So that's what I'm trying to get to, that having a custody evaluator in any case where there's been a disclosure or discovery is always inappropriate, because you haven't dealt with the primary issue of safety first.
But the courts use the custody evaluators, right or wrong. And I mean, I think there's an argument here that custody evaluators should be prohibited from participating in custody cases, from what you're saying, because the courts use custody evaluators to help them decide whether abuse actually occurred or not. So that may be improper.
Yeah, it's inappropriate. They should
Right,
Yeah, I think that's part of the problem.
Yes,
That's part
right.
of the problem.
We're trying to fix that. So if we look at this task force as court reform, we are reforming what is a train wreck in
Correct.
all of the family courts across this country. We're fixing it. So Lori, I hear what you're saying, that this is how things are right now. We're saying that's not working. That's harming kids. We have to completely reform that. And part of that reform is removing custody evaluators from any abuse process at all. It's inappropriate. It's always inappropriate. They are not informed.
What I'm saying,
Go ahead, Claudia, sorry.
what I'm saying and what my question is, we don't have a process, an investigatory process ahead of in a child custody case. And I think this is what Lori is saying too.
Right.
That doesn't happen. There is not I agree with you. I think the decision, and then one of the things is that should the decision be made ahead? That's something, do we make a recommendation when there's child abuse and neglect or domestic violence, whether that, there's a decision about whether that has taken place or not before decisions on custody are made.
So that would certainly be a wholesale change of our system. I mean, it would be a wholesale
It's not a
statewide
we
change.
still have the confrontation clauses. We still have due process. We still have the adversarial system in place, defense, plaintiff, all of that is, nothing changes in that regard constitutionally.
I understand, but here's what I see is if this became law, that there was no custody evaluation, happening until a precursor determination of whether there has been domestic violence or sexual abuse, then you'd have some cases where both parties are, honest, straightforward, whatever. They say, no, there's been no abuse. We just both want custody and, so then a custody evaluator would be appointed to make that best interest determination in cases where there are no allegations on either side of any domestic violence or child abuse.
That's not covered in my recommendation. My recommendation is exclusive to where there is a disclosure or a discovery of abuse. So imagine you're going along in a divorce case and a disclosure or discovery up, which is often what happens, right? All of a sudden there's a flag on the track. Everybody stop. There's not going to be a custody evaluation. We are now shifting to a specialized judge with specialized training, a special GAL, and we're removing custody as an issue right now because we're dealing with safety. In your scenario, Lori, you have two parents who get along. I suspect a lot of them are going to be able to use mediation and come up with a joint custody agreement all on their own and save themselves a lot of money. But if there are litigious issues around cars and property and bank accounts and businesses and things like that, and custody becomes part of that divorce proceeding, but they're still amicably able to resolve that and there's no abuse, then the custody evaluator can come in, the court can do whatever it wants. But if there's a disclosure or a discovery at any point during that process, it's out. That's what I'm trying to say.
Okay, I understand that. I think today that is a huge, huge change in Maryland law that you're proposing on the last day of our recommendations. And to finish my thought, so in the cases where there's no allegation, fine. Then there's a custody evaluator who says, I think it's in the best interest of the child after interviewing grandma, grandpa, mom, dad, healthcare provider, children, everybody else, that child go with this parent on this schedule. That's what I want. But I'm telling you what will happen. What I think the unintended consequences of something like this is that every lawyer will figure it out and every litigant will figure it out. And then all they have to do is allege some kind of domestic violence or child abuse, and they don't have to use a custody evaluator through the courts. And I'm not, I find them to be more negative than positive. Believe me, I don't think that we, as an organization, love custody evaluators in any of our court systems. We think that they are flawed and not very good at their job. So if the consequence is that it fades as a part of family law litigation in Maryland, maybe that's the consequence you're after. But here we are on the last day of our recommendations. And I mean, I just think that the integrity of our process would require more discussion about such a sweeping change. And I said, I'm not saying I disagree with you. I just think it needs more conversation.
So the point is, let me interrupt for a second. The point is that if indeed we believe it's flawed, and I think I've heard everybody say that it is flawed, then there's nothing wrong with us, and we're not doing our job if we don't mention that or bring that up. I don't think this is something suddenly coming in at the very last minute. I think it's actually been there underlying for a long time to our whole process. So I understand your concerns, Laurie, specifically.
So I'm perfectly comfortable with a recommendation that says we need to look at how this is done, and that this, may be what we should get to in 2 years or something. But I get, Mr. Secretary, that the conversation has been that custody evaluators are part of the problem. I absolutely agree with that. And I know that that's been part of this discussion for a long time. But I think to make a sweeping recommendation to sort of get rid of them entirely in any case where there's an allegation, I think you'll find false allegations being made just to get out of having to have this custody evaluation. And I mean,
but right now it's not even mandatory, because I did not have a custody evaluator. So it's not. It's
decided by the court. I agree with you. It's not mandatory.
Right. So,
Mr. Secretary.
So we for a second. So if we think it's fatally flawed, that it is an issue, and I heard you say that just a few minutes ago, Laurie.
I think it's flawed. I wouldn't say fatally. I don't know.
So it's flawed. All right. So it's seriously flawed. All right. And I think we've heard others say the same, if not a little stronger, from, again, personal experiences and working these. There's no problem with us bringing that to the attention. That's what we're here for. We're here to zero in on the areas that we really think need to be fixed. And, that may take a year or two before we get to that point. But in terms of making the point and making sure we cover that, and that we make sure that the legislature understands that issue, and certainly the points that you've raised will clearly be raised again by others during the process. But I think we can help bring that to the fore, and the legislators will be able to work that, even if it's a radical change. And we do say, we know this is something that needs to be fixed, and across the country, not just here, but in Maryland, which we're obviously focused on. But why not address it? Why not take it on?
I think it depends on the language of the recommendation.
Jen, go ahead.
Yeah, weigh in. I'm really just doing this as I want to be an impartial observer here, but before we can even get to the legislation, we do have to write a report. And I'll admit, I'm confused if the intent of the recommendation that Camille has raised today is to basically get rid of custody evaluators generally for the process of abuse and domestic violence allegations, which is all that the work group is focused on. I feel like that contradicts a lot of our other recommendations.
Right.
Why do we, I mean, why are we going to tell custody evaluators who, in cases where there's disclosure of domestic violence and or child abuse or neglect, what training they need when when our other recommendation is for them not to even be used? They seem to be contradicting
That's my question.
Mr. Secretary,
without further clarification.
One at a time, guys.
Mr. Secretary.
Yeah.
Yes.
And I'm going to go ahead and address that if that's okay. One is the scenario where you're in the investigative phase. Two is the scenario where abuse has not been determined, the courts hasn't been able to make a finding, and then you bring in the custody evaluator, but they have to have the specialized training, right? So I'm not saying my recommendations are consistent with what we're saying. It's not saying get rid of custody evaluators altogether. It is not saying that. It is saying there's two types of scenarios here. Under those scenarios, here's where it's appropriate or not appropriate to have a custody evaluator and what their required expertise should be.
Can I just add, Camille? So just anecdotally, our experience is when if a custody evaluator is assigned early on in the process, essentially the abuse allegation or discovery is pending. And so I read this as, is there a way to postpone a custody evaluator's final decision-making if only 2/3 of the family partners, so say it's both parents in the courtroom and the custody evaluator is busy kind of vetting both of them, but they don't have a mental health assessment of the child. So while the custody evaluators go through this training, it's training to be a custody evaluator, but not to do a trauma-informed assessment of the child. So the custody evaluators have to integrate a trauma-informed assessment of the child, which requires postponing final recommendations, right? Because that can take time, and who does it is a different question. But what we're talking about is how the custody evaluations can integrate the child's voice by a trauma-informed provider. The custody evaluator is not going through this training and becoming, having the capacity to do a child assessment, right? They need to get that data. So if pending, we postpone any final recommendations until there's that child-centered data of, is this child safe and or at risk of further harm? And until we know that, there can't be any final recommendations to the court.
I like the idea. I like the idea of postponing. If something's already in motion, that's great. The thing I'm concerned about is that what I've seen in a lot of case records that I've read is that you have custody evaluators that look at everything through the prism, even a really great forensic evaluation, trauma-informed interview of a child. They're still looking at it through the prism of friendly parent doctrine, and it skews even their ability to objectively incorporate that into any kind of custody final report. It really skews it. That's the piece that's wonky, is that we have custody evaluators inserted into cases where there's the need for highly specialized people. Sometimes those people are in that child's life already. People like you, right? People that are employed at CACs and people like that, and therapists that are specialized in child sexual abuse. And a lot of damage can be done by one custody evaluator, because now it's on the table as something the court can use to weigh their decisions around the safety of the child. And it comes in and it actually undermines that real expertise that you have. So I do like the idea of postponing, but I also am very concerned about having any kind of custody evaluation in the context of a case that has been where there's a finding, right? Because they still get wrapped around the axle or on the friendly parent doctrine around it. That's the concern.
And maybe this speaks a little bit to recommendation 21. So if it's postponing until there's this child-centered, trauma-informed assessment of the child's, level of risk and recovery needs, right? So the data collecting with the child first, if there's an allegation, that's primary, that's the most data that's needed. And I was just looking at 21 because there's 2 points there and the postponement may be included there. So it's kind of everybody stop, and what does somebody with knowledge of this say about not only what verbally is reported, but what stories does the symptoms tell, and what does a child need in the short term?
Mr. Secretary,
Yes, please.
I'm just going to take a step back and just kind of bring this back to first talking about custody evaluators and why we spent so much time on all of these recommendations. If we go back to our, when we were holding the hearings and briefings, and what we found through that process were two major observations. One, that the judges do rely on custody evaluators, and two, that many of the parents and parties did not even know that custody evaluators, that was an option for them. So if we can first take a step back and we start in our recommendations on custody evaluators with recommendation number 11, that's where we're talking about providing the information to the parties. It also leads to, being able to say the value of the custody evaluator in order to provide information for the best interest of the child. So I'm trying to take it back to a general level, first of all, of why we have focused so much on custody evaluators, and then as we get into number one, the fact that we acknowledge that because they have played this instrumental role, and in some cases, as has been pointed out, there's been flaws in that process. So we're going through this whole process of strengthening the roles of custody evaluators so they can actually provide the service of best protecting the child in these proceedings. So any of our recommendations, and I guess I'm looking at the actual wording of it, should, take all of that into account. And my only concern about at this point, limiting the custody evaluators, would be that if that, again, could be used as a reason that if that they can't even, here we're going to go to all this trouble to train them, let them have, develop their expertise. But if there is a legal way that, that one of the parties may see that all I have to do is make an allegation and then not have the expertise or value of the custody evaluator, I would be concerned about that. So I want to go back to, why we were focusing so much on custody evaluators, and also just because I'm the layperson here, just say the average person doesn't even know what a custody evaluator is. So like when you go to recommendation 11, maybe there's just some language in there that can just say the value of a custody evaluator in protecting the children, bring it back to who we're trying to protect, then that really underscores the importance of the training and making sure that these are strong. We're trying to strengthen the custody evaluators. So if the judges are saying that they depend on them, that that they will have the best highly trained custody evaluators who do have the best interests of the children at heart. So I know I'm taking it a step back, but as a layperson who didn't even really understand, and hearing from the parents that some of them didn't even know this was an option for them, and underscoring the value of those custody evaluators, before we get into, I think, any of this detail. So I kind of hand that back over to you, because this has been the area of focus. And I think this work group can serve a real function in making some recommendations that will strengthen the role of these custody evaluators across the board.
Mr. Secretary?
Yes.
May I just ask Camille, if I tried to get some of that investigatory, adjudicatory language out of the recommendation, since, like you said, that's not really the way we look at family law here.
Lost you, Jen.
I'm going to read you. Whoops. Can you hear me now?
Yeah,
I can hear you now. Go ahead. Yeah, you need to repeat what you just said. Now you're
Sure.
lost again. For some reason.
Are you there?
No. Now we are.
Okay.
I can hear you fine.
Camille, I'm going to read this. Is this more what you're saying The court shall not appoint a custody evaluator until a specially trained judge has made a preliminary assessment of whether there is already admissible evidence of disclosure or discovery of domestic violence, abuse, or child sexual abuse.
Not quite, but if you send me that exact language, I can try to wordsmith it a little bit today.
Well, we'll need to do it if we're going to make it a recommendation. We need to do it before we wrap up the call.
Before we close. Right.
We can't be doing deliberations outside of an open meeting. So let me.
Can you put it in the chat? And can you make sure everyone has, everyone on the task force can see it in case they want to add some wordsmithing to it as well? You know, Paul,
Yeah.
Paul, if you could help a little bit on this, I'd be appreciative.
And I may be missing the mark
Absolutely.
altogether for what you're saying, so.
And so those of you who are close to custody evaluators, and I am not one from a children's advocacy center, I think what I'm understanding is that the custody so number one, I second what Camille is saying, is to kind of put a pause and to allow the child abuse process to run its course. I mean, there is a statutorily created process for every single allegation of child abuse in the state of Maryland. And it sounds like the custody evaluator is allowed to run on a parallel track, even though that's not there, even though they shouldn't be doing that. What I'm getting from this call is they are absolutely allowed to leapfrog over whatever finding has come out of law enforcement or CPS. I mean, Lori, I heard you say that in child abuse cases, 80% of your cases don't have a CPS or law enforcement finding. But if there is an allegation of child abuse, it has to go through the process, 100% of them. So I'm not understanding the disconnect. In what world is there an allegation of child abuse that's not investigated by the proper authority?
CPS hasn't received a report? Is
Well,
that
then,
what you're talking about?
Yeah, and so I don't understand why that would go to a court to decide before it even comes to us, the child advocacy centers that are set up in the state to work on these multidisciplinary teams to assess and investigate and do these interviews. Do you see what I'm saying?
So
Like,
I mean, first there's the criminal avenue and there's the civil avenue. So I suppose every case where there's a criminal allegation of child abuse, there probably is.
Every time there is any reason to believe there is child abuse or neglect in the state of Maryland, that comes to CPS or law enforcement, and they send it to a CAC. We have nothing to do whether it's criminal, custody, or civil. It's any allegation in the state of Maryland comes to one of the CACs. There's one in every county except one. So I don't understand why.
And then do you investigate?
We do not. We do the forensic interview. We do the trauma-informed mental health. We do the family advocacy. Those findings go to our two partners, law enforcement or CPS. That's it. That's the process. Our data, and then law enforcement and CPS, they make a determination whether or not, if it's CPS, it's ruled out, it's unsubstantiated, or it's indicated. On a separate track, law enforcement is going to do what they're going to do to decide if it goes to criminal prosecution. We're in the back. And so I don't understand why.
So what I'm saying is that in domestic violence cases, there is frequently, probably more often than not, no CPS investigation going on. So what happens in a protective order, though, is if you're seeking, because of intimate partner violence, you're seeking a protective order for yourself and your children, then CPS or DSS does an evaluation about the custody piece. And so there's not necessarily an allegation of direct abuse to the child. And we can all agree that children living in families where there's intimate partner violence are suffering the consequences of it. I don't have a problem with that. But there's not any, the mom hasn't said, and he's beating our son. The mom hasn't said, and he's sexually abusing our daughter. The mom has said, he's beating me, and here are my hospital records, and I want a protective order for me and my children. Then there's a CPS investigation. And so there's not an allegation of direct child abuse in the concept that the people have of a child experiencing abuse. And so in many custody cases, that is a scenario that you see. If there's no protective order, you have let's say a woman filing for divorce on the grounds of cruelty of treatment, which is intimate partner violence. She wants custody of the children, but there's not an allegation that he's also beating the son or also sexually abusing the son or daughter. There's no CPS involvement at all in those cases. So the court in that custody case is left with the decision of, is this allegation true or not? That mom says he's verbally abusive, he hits me, but he's verbally abusive to the children. He's using the children as a part of the power and control dynamic. And it's the children don't want to go there because he's so, focused on me and whatever reasons they have. There's no CPS involvement. There's no law enforcement involvement in any of those cases. And so what the courts do is rely on the custody evaluator, which is, to Camille's point, that they are not necessarily experienced enough in the nuance or the details to understand that psychological abuse is abuse, to understand that living in a household where one parent is abusing the other parent has long-lasting trauma effect on these children. I totally concede and agree that these custody evaluators do not take those scenarios seriously. But when I go back to the language, there is not an investigative or an adjudicatory or a disposition part of these family law cases. There's discovery, and I can try and discover, if the child is seeing a therapist, and then I have to get a waiver attorney. There's discovery, there's settlement, there's litigation, and there's a decision by the court, essentially. And this, and the court does rely on these custody evaluators, which I totally grant you are very imperfect. But it's not that there has been a finding prior to somebody filing for divorce in custody that abuse has occurred on either the mother or the child. It's an allegation.
Yeah, Lori, I've seen a lot of cases where you have a divorce, never married, custody litigation going on for years before there's any kind of disclosure. And the disclosure comes up in the context of that divorce custody litigation, which then makes it more contentious, right? Yes. So to both of your points, Joyce and Lori, I think that are there scenarios in Maryland ever where in that context where you have all this pre-litigation and then a disclosure, are there scenarios where the court does not on its own motion make a mandated report to CPS or law enforcement and has its own preliminary protective order, family abuse order, abuse investigative process?
Let's say in the middle of a settlement conference with the settlement judge, mom says, my son's therapist just told me that he revealed that dad did X to him. So you're really 3/4 of the way through your case. All you have left is the trial if you don't settle. So at settlement, mom says, this week the therapist told me that little Joey said that daddy has been sexually abusing him. I think the court could order a CPS investigation at that point, or if they don't have the custody evaluator, if they didn't order a custody evaluator, they could then order a custody evaluation. But they don't say, I'm putting a protective order in place. I'm sorry?
Which I think is what ends up happening is sometimes the judges will defer to what they know, the tool that they have in their toolbox is custody evaluator, right? So they go in the wrong direction when it does come up in that context. But are courts in and of themselves under Maryland law mandated reporters?
Are judges?
Hey folks, let me interrupt for a second. We do need to come to conclusion on this today. This is our last meeting. So we need to get some language together that covers this. If we're going to do it, we can do this in maybe some broader language rather than specifics. But we do need to come up with something now, and we have a little bit of time yet. We're not at the end today, but we do need to finish this out today. This is important to get done. Do we have some language? Yeah, go ahead, please.
I'm gonna give it one more shot in the chat box. If Paul, if you could come in and help me wordsmith it in the chat box, that would be really helpful. Because I don't want to inadvertently put some legalese in there that gets it sideways.
Sure.
Camille, just to make sure that we, again, this is an open meeting and the public can't view the chat box. So I know we've used it, but let's just make sure that if we're deliberating the words, that we're actually reading them aloud as well, so that the public has the opportunity for observation.
Okay, once Paul and I have something down, then we can read it out loud. Yeah.
Okay.
Okay.
And I just want to say one thing about, I really think we don't have a process in place. And that's really, I mean, I understand the reasons we don't want evaluators making these decisions for the judges, or the judges relying heavily on them when in regards to child abuse and domestic violence. However, we don't have a process in place. And that's what I think has to be, I mean, it's a complicated recommendation. And I'm not sure what we're going to come up with.
So I much prefer broad language. I much prefer broad language because I fully recognize the problem, but a broad language to assess, I mean, I can't exactly come up with it, but there should be investigation into the process by which custody evaluators, including when in the case they're appointed and what their dictate is, what the court has asked them to do, because courts probably shouldn't be saying, and I want you, custody evaluator, to determine whether abuse has occurred or not. Like we don't want custody evaluators doing that, is my understanding. So so maybe language that says, something broader about when they are used in a process, it should be for X purpose or something like that. Perfectly comfortable with that, but I really can't get on board with the language that Camille proposed. I'm sorry, Camille, I don't mean to.
I hear you, Lori. I put something in the chat box that kind of, I think that's where we're going. Tell me if that gets there.
If there is an allegation of child abuse, I'm reading it out loud for the public. If there is an allegation of child abuse, the court shall not appoint a custody evaluator in lieu of reporting the abuse pursuant to Maryland Family Law 5704. And then it just went off my screen. And Family Law 5705. A court may not appoint a child custody evaluator to investigate child abuse. And I'm sorry, I'm having trouble getting it lined up. I can't read the rest of the sentence, I'm sorry.
A court may not appoint a child
allegations, okay, to investigate child abuse allegations. So that makes perfect sense to me, that's the wrong tool for a court to use to get to the bottom of whether abuse has occurred. And that's what that's saying, right?
And yeah, and those 2 points of law, 5704 and 5705, are the state's mandated reporting laws. 5704 is for professionals who work with professionals generally who work with young people. It includes custody evaluators. By the way, they are mandated reporters. I don't know why they're not calling this in. Maybe they are. 5705 is the general public. Everyone in Maryland must report child abuse in the state of Maryland. There are some exceptions for lawyers, but those are our mandated reporting laws, and they're not guidelines. There are penalties if you fail to report.
Just one thing I touch on, maybe not the criminal side, but certainly in Child Protective Services, they're going to have their decision or their finding probably on vast majority of cases well before your first scheduling conference or first real contact with the court. If I file a custody case today and I also make an allegation of abuse and CPS gets it, before we ever get in front of a judge, they're going to either ruled out or ruled in the abuse. It doesn't take that long. Now, criminal obviously is different. That can take a lot longer. But I don't think they're going to have too many times where judges are going to have to pause the process. Not too many times. It's going to have to pause the process to allow CPS to continue. Not in a custody. Certainly in a protective order, but not in a custody case. Does anyone
CPS
have
has to
any difference?
decide within 60 days
Right,
after the allegation. So
right.
they have to decide
and-
within 60 days.
Right, and usually it's before that, as a practical matter. Because, you don't get in front of a judge when you file a custody case for.
It's
so it depends
45 days
depends
to the scheduling conference. 45 days from the answer being filed to the scheduling conference in most instances. Now, some courts
Right, and
are
the answer,
faster than
so
that, but
and that's 30 days, so you add 30 from the answer, so that's 75 days right there. And even if you get in at day 55, it's not going to be that many days before a judge will have to wait for the process to play out. And usually they make their decision before the 60 days.
but you're talking about somebody who's at the outset of their custody case says, and there's been abuse.
Correct.
You know,
That is
Camille's, one of her
correct. That is
hypotheticals
correct.
is in the middle of litigation, there's a discovery or disclosure. So that's a different scenario.
You're right. It is a different scenario.
Yeah, Paul, can you check out what Joyce and I both put down and maybe
All right.
pull together a combination of the two?
All right.
Is that on the screen in front of us now?
It's in the chat box.
Yes.
Yeah.
Okay.
Is it on the screen?
No, it's in the chat box.
Okay, I'm looking on the chat box. Okay. We've got the stuff that Joyce said about 5704 and 5705. And then we have the language from Camille. It says, in any case, including any ongoing or current divorce or custody case where abuse has been disclosed or discovered, the court shall stay the custody proceedings and refer the case to the appropriate authorities and to a special judge to make determinations about abuse before any final custody determination. I think that's fine. But that looks like it's more related to our other recommendations about specialized training for judges.
I have 2 points on that. One, I assume when you say abuse, you mean child abuse, because I want to be very clear about separating child abuse from domestic violence allegations. Sorry about the background noise. And number 2, I don't want a judge to make a determination about abuse. The judge also has to wait for the process if there is any. I understand that courts have to, decide if CPS or law enforcement has ruled out unfounded. They have to interpret that data, but they are not the ones deciding whether or not the abuse occurred if there's an ongoing investigation.
Joyce, could you do me a favor, Joyce and Paul? Could you cut and paste what's there and
Yeah,
then in
sure.
the chat box rewrite it to include your suggestions? I don't know how to translate what you want into what it says. So
Okay.
Joyce, are you on a computer? Because I'm on a phone.
And
All right. Do you mind doing that?
what everyone signed up for is writing by committee on Zoom.
Thank you.
All right, let's turn this off.
we're making
No, this is a similar recommendation from the initial report from 1984 when they were doing 9101. They had a similar recommendation that CPS should do an investigation, and then they amended the bill.
Oh, why did they amend it? Michael, do you have any insight?
Yeah, we could talk offline.
Roger.
Okay, what we have up on the screen right now is draft recommendation 1. Is that there for a reason? Jen, do you know?
I think we're just on pause while
Oh, on pause. Okay.
Yes.
Okay. That's fine. So this really is our last point that we really have to get resolved today.
Thank you for your patience, Mr. Secretary.
Absolutely.
This is all good. It's all good.
Right.
Okay.
Well, and this is so difficult too, because obviously this is right in line of how we're trying to change the judges. So it's the kind of the same concept with the evaluators, right? So we're looking at people who are making decisions who don't have the best interest sometimes at heart and are exhausting financially these people, and coming in on the behalf of maybe one parent as opposed to the other. So this is why this is very difficult. And I think as we move forward and start looking at legislation, I think we can dive a little deeper into this and get more specifics on what this really looks like and what this really means to the cases, and that this weighs heavily on the outcomes of these cases. So I think it's in tandem with what we're trying to do with the court system, kind of specialized courts. It's the same thing with the evaluators. They have to be committed and they have to want to do this work instead of being hired as a business. So we have to keep that in mind as well. And I think if we move forward and knowing that, which we all do, I think we will be somewhat on the right track when we start legislation. I want people who are listening into this, we do understand those different issues that you're addressing and you're concerned about, and you're in your cases right now, and you feel this bias and you're exhausted financially, and you're angry. And so we recognize that. And we know that this is a huge thing, and this is not this is the beginning, this is the end to a beginning. So I just want to make sure everybody knows that we are not giving up on this issue. Whatever you see today, again, I'm going to restate it. We do know better, and we will do better. So just, I want you to know we're right there with you, because I know some of you are thinking, oh, they didn't add this, they didn't add that. It's not that right now we're not adding it, but we know it, and we will move forward in that way. And this team.
Yeah, that's a very good point. I'm glad you made that. And I think we're all in agreement on that as well. So are we, Jen, are we close to, okay.
Yeah, this is, Joyce's language is good. Can we put it up on the board for everyone to see? Jen, is there a way to?
Want me to read it, the second one?
Yeah, I can read it.
All right.
I just read it.
I think this captures, in any case, including any ongoing or current divorce or custody case where child abuse has been disclosed or discovered, the court shall stay the custody proceeding and refer the case to the appropriate authorities, CPS or law enforcement, to investigate the allegations pursuant to Maryland Family Law 5704 and Family Law 5705. A court may not appoint a child custody evaluator to investigate child abuse allegations. The case should also be referred to a special judge pending the outcome of the investigation by the appropriate authorities.
Here's my only concern, is I don't want this to be read as the court's going to make a de facto deference or grant de facto deference to Child Protective Services if they make a rule out. And we address that under the training of judges, that there are limitations to what CPS can do.
I wholeheartedly, that really concerns me.
We already have that. If you look at draft recommendation 9, subsection 3, we already have that taken care of from our last one. So yes.
No, I agree with you. I just don't want this to be misconstrued as, oh, so we're going to let CPS make the determination. That sounds good to me. I mean, I can see judges do that.
That's not what it says.
So here's my question about that drafting. Who's the special judge? What does the word special mean? I know some special judges, but
you're married to one.
Not necessarily in a good way.
That's not mine. The special judge isn't mine. I just took that from what was there before.
Specially trained judges.
I'm not sure what that means. That's someone else's to.
If we're having specialized judges on these cases, then I guess we're going to have to put that into the code under definitions, maybe.
Something. I mean, there's got to be some way to reference what a special judge is in this statute, because it doesn't.
Well, I think we could. Can't we refer back to the our language to specially trained judges as referred to in recommendation X, whichever one that was?
Yeah, I think this this subsection is for custody evaluators, so should we probably take that out and just leave this specific to custody evaluators? As you all said, elsewhere in the document, we say, hey, all of these should be going. If there's an allegation sometime in the process of child abuse or DV, that should be going to the specialized court pursuant to recommendation, whatever it is. I think those are two separate things.
And we're saying that this is where one of the parties or somebody related to the case discloses or discovers the child abuse, not the judge, correct?
Joyce is nodding her head.
Yes.
My understanding is that in the scenario that Camille and Lori were giving us, everything is going along. This is not a child abuse case. It's not a child abuse case. Boom, all of a sudden it is a child abuse case, it being a family law case. Now it's a child abuse family law case, different. And so the allegation arises in the course of it. Does that answer your question?
I hate to be cynical, but I also see the unattended consequences of this, because we usually represent the economically dependent spouse or parent, and it's a pretty nice delay tactic when you're at settlement court, which is about a month before trial, and then all of a sudden say, for some reason, there's an allegation of child abuse, full stop. We're not going to get our trial date. I mean, we're already right now, because of COVID, getting trial dates over a year away. And these are sometimes people who are not getting any child support. They're not financially independent. If there's divorce, there are other issues involved. And this delay can be really damaging for some litigants. So I just want to put that on the record, because I'm not a huge fan of delaying resolution of these cases.
And I think the entire point of the work group is to combat the presumption of fabrication and err on the side of kids. I mean, in my experience, I have protective parents who tell me they don't want the allegation of abuse to come because it's going to screw up their custody case, and they would prefer the child didn't disclose. But you know what? She said that she was being fondled in the bathtub, and now here it is. So I think yes, there's always unintended consequences, but our job is to err on the side of combating all of this fear of fabrication that people have when you mention the word divorce.
But it's great until they're rendered homeless and have no food. So,
But I just want to point out that part of the work that we're doing here is to protect children. And any child abuse disclosure, children don't disclose at convenient times. Children disclose when they're ready to disclose, or red flags go up when they go up, and even if the child doesn't disclose. So I would really like to stress that this isn't about convenience. This is about what Joyce is saying, the protection.
I get that. I will also, if I could just note that this is only
again.
about child abuse. This is not about domestic violence. And that's a whole, there are people who are victims of intimate partner violence who also don't disclose in a timely or convenient manner. But the suggested language is only addressing child abuse.
Well, what we're concerned about is the safety of the child, okay? And that's, we've been doing that.
Is that a suggestion that we're not concerned about the safety of the victim of domestic violence?
Of course.
No, I mean, do you want to include that into
I don't know. I can't draft like this. It's not my skill. I admire Joyce for doing it, but I'm not sure what it would look like.
And Lori and others, I think we're only talking right now about the really narrow circumstance of the child custody evaluator. Like, we're not, right? I mean, I think this little tiny section is just, hey, should the child custody evaluator be appointed to resolve child abuse allegations? No, and here's how. I don't think, even other things, Lori, you were saying about delay in the whole process, I think it's narrowly drawn, but I always think that about legislation, and then.
Right.
Well, my concern, I just want to reiterate my concern, which is that the language is not clear to me about when the court is obligated to make the referral. I mean, I think it should be, if somebody brings it to the court's attention, not the court independently deciding that there may be an issue of child abuse here. And so the court is now a mandatory reporter that needs to contact Child Protective Services and make a referral for this family.
It's a good point. I think now that I'm looking at this, and you guys help me out. When child abuse has been disclosed or discovered, you can still keep going with your family law case, right? I mean, you can still keep going. What we have is shall stay the custody proceedings. Help me out. But I think all we were trying to say here is you can still go. I know that's a very slow process. By the way, you have to report the child abuse. You cannot have a child custody evaluator come in and handle these allegations of child abuse. You have to report it to the authorities. And I think you can keep going along with the case. Does that comport with those of you in family law who handle these cases? You see what I'm saying? It's only the child custody evaluator as the investigator.
That's not what this recommendation says. It says the custody proceedings are stayed, so it stops. And Mike, I do have a concern about what happens. So, I mean, I was involved in a case where the judge made a custody determination for the father, and it was if everything were stayed in the midst of this while we wait for investigations, the child remained with the parent that was abusing them. So if you're staying all proceedings, I mean, that's a little, I don't know, seems.
That's an excellent point. And I'm not sure, right.
Is it postponing, final decisions about placement and visitation? It's just, postponing anything final where there's temporary measures to ensure safety during the data gathering phase. But
yeah,
it's you're talking about temporary, and it's just before a custody evaluator comes in and, kind of on the throne and makes these recommendations, we need to hold for anything final and just put temporary protective measures in place.
I just fixed it. See if that gets at what we were saying. What I changed it to, in any case, including any ongoing or current divorce where child abuse has been disclosed or discovered, the court shall report the case to the appropriate authorities, blah, blah, blah. A court may not appoint an evaluator to investigate. I think that's all we were trying to do with this language. You see what I did? I didn't say just stop everything, refer it, don't put a custody evaluator, let's keep going. I think that's what we're trying to say. So thank you. I heard you.
So I have concerns about that, because then you have two tracks during a potential abuse investigation where you have a custody proceeding still going, potentially with a custody evaluator, and a separate track with a CPS law enforcement investigation. I think
exactly. I don't see how it can keep going when there's an allegation of sexual child abuse. How can it keep going?
You have that anyway. I mean, at no point is the court the one charged with investigating child abuse. I mean, we have those cases all the time where someone's in custody. By the way, she's one of our clients. Her case is winding through the process. She doesn't stop her family law case. These things take a long time. CPS and law enforcement do what they do. It's not two different tracks. It's the job of CPS and law enforcement to investigate child abuse in the state of Maryland. But
if the custody evaluator is continuing to proceed on their evaluation and make some type of recommendation while there's this abuse allegation hanging out there, that also can go towards the detriment of the child. And for the reasons I stated earlier, that they get it wrong. They look at the friendly parent doctrine. They're not specialists in abuse. So it's again sort of poisoning the well for the child's sake. So I don't think we're quite there yet. But I to the point that was it Joyce that raised the point? Joyce, who raised the point about, maybe it was Claudia, about then the child, if you completely stay the proceedings, the child might actually still be in the custody of the perpetrator. So there's some validity to that. I don't know how to address it.
Yeah, I wanted to put something in here too, that
while an investigation is going on by CPS and or law enforcement, it's very possible that they would not want a custody evaluator questioning the same people they're questioning and interfering with the investigation. So that, I think, has to be taken into consideration too.
Oof.
Oops, I had to jump off for just a minute there to take another call, but
Mr. Secretary?
Yes, go ahead.
I apologize for interrupting you. I know that this is the last meeting. I think what we're working on right now is really important. Is there any way that, would it be outside the realm of protocol for me to make a motion to just have one more half-hour meeting at some point to just deal with this one recommendation to get the language right? I feel like we're rushing through it and we're missing a key piece of what might be important to include.
Okay. Jen?
I can't say at the meeting whether or not we can have another meeting or not. There's some protocols that we have to do as well. So we can certainly try to get permission for that.
Okay.
But I can't give a resolution at this point. I would just point out that if we do have another meeting, we did, when we sent out an email, I think 2 weeks ago, right after the last meeting, we did ask for any, new recommendations such as this one to be given to us by last week at 10 o'clock. So if we do another meeting, we really need to abide by that and not raise an entirely sort of really a new recommendation at this point. Otherwise, we're never going to get done with our work.
I fully understand that. No, we will keep it only to that one item if we do this. Jen, how soon would you be able to tell us, Jen, about whether we can get that additional meeting?
So we can't really give a set timeline. Like, we can check on it, but we need approval for it. So we would have to obtain approval.
Okay, and go ahead.
May I just ask, that recommendation, my understanding is it would be something in addition to what we already have. So nothing that we have now would necessarily change. This would just be adding an additional qualifier on the custody evaluator process. Is that accurate?
I think it's clarity. We're getting some clarity on some of the issues. Yeah.
Yeah, I think that's accurate.
So again, we can reach out, but we can't say right now, when the next meeting would be or anything like that. We don't have that authority.
Hey, Jen, can I interrupt for a second? Paul Griffin got kicked off the Zoom. He can't get back in.
Back in.
He's asking for permission to get back in.
I just allowed him in. Yep.
Thank you. I'm sorry about that.
Wonderful, thank you.
I am back.
So when we were talking before about this recommendation, we talked about first we were saying the custody proceedings had to be stayed. I think the concern you have, Camille, is that there still be ongoing custody evaluation ongoing. Could we just put in here that the custody evaluation process has stayed, or whatever the terminology is, and the rest of the other things can keep going on, but there's not an ongoing interviewing and all the other things that go on with a custody evaluation that could get in the way of an investigation by CPS or law enforcement. I mean, that's, I think, one of the reasons we wouldn't want the custody evaluation going on during the time is that it could get in the way of the other point I really would like to make sure that was included in it is that the CPS, if we're going to do this, CPS and law enforcement their determination cannot be what the judge accepts either. I mean,
I agree.
the parties ought to be able to bring in expertise
Agreed.
to determine whether abuse or neglect happened. You cannot, I mean, CPS and law enforcement are making a determination based on the SINA statute and the criminal statute. And we don't want these cases. I mean, I don't think that's in the best interest of children to make those, because there are many times when you don't know whether it happened or not.
No, that's true. And that's covered, Claudia. You are right. And that's covered under the judges section.
It's only in training. That's only in the training they're going to get, Joyce. I'm pretty sure it only says it's only in, here's what they need to know about, but it's not in the procedure that they have to follow. And I do think that you have to allow in other expertise, because people should be calling in experts to talk about that.
Yeah, to interpret the data.
Yeah. I mean, CPS will find we don't know whether they'll have unsubstantiated. A lot of judges think unsubstantiated means it didn't happen, or we really can't tell, so it didn't happen. And but there are lots of times with especially small kids where it did happen, but they're nonverbal, or they're, and that's just to give custody in those cases without having expert witnesses is just beyond unsafe for kids.
I would agree with everything you just said, Claudia.
All right, so what do we have? What do we have now in terms of the language? Jen, is that possible to put up what we have?
I just typed in Claudia's comment, and it now reads, in any case, including any ongoing or current divorce or custody case where child abuse has been disclosed or discovered, the court shall postpone appointing a custody evaluator and report the case to the appropriate authorities pursuant to the law. A court may not appoint a child custody evaluator to investigate child abuse allegations.
So I would just say, instead of just postpone appointing, because some have already been appointed. So we need something.
Yeah, postpone, continuing, or appointing.
Shall stay the appointment of, how's that for convoluted?
But I think we're trying to get to it. There might be already in the middle of the custody evaluation process. So you need to say in those cases where there already is one appointed, but it's not finalized yet. So
suspend or postponed.
Yes, there you go. Better words, suspend.
Yeah, or postpone final recommendations.
Well, we want to postpone them interviewing and everything else too, right?
Yeah,
right.
And getting in the mix, yeah.
All right, I'm saying the court shall suspend or postpone the involvement of a child custody evaluator. There.
If I could just remember or remind people or something that we're not supposed to be drafting actual legislation.
True.
So here we are in an exercise of drafting actual legislation that the DLS may not be able to use, or may say it doesn't meet with their conventions. We do this all the time in Annapolis. We give them language and they come back and they say, you can't do it that way. So,
yeah, that's a good point. That's a good point.
And I thought that was the secretary's comment was we're not supposed to be drafting legislation. So
can't we just say this is a recommendation in any case, blah, blah, blah?
I think that's what we're trying to do. I'm just making sure that I'm clear on what the point of this recommendation is. So I think that's why maybe we're doing a little more drafting than is necessary.
Yeah, just don't feel like you need to get bogged down in cross references to other law. We just need to have specifically, not to Jen, but to everybody else, we just need to have really what we're going for in terms of process. Okay. I will likely be drafting this in the future, and I can do the cross references I need to do at that point. So.
Right.
In that vein, here isn't something we're getting at.
I'm happy with this language. Sorry, Michael. Sorry.
Go ahead, Michael.
Just in this vein, just as an elegant part of this with a big hammer is, don't we want to make it explicit that judges are mandated reporters, that custody evaluators are mandated reporters? Looking at 5701, it's far from clear that they are. In fact, I don't think they are.
Are you saying we want them to be? I don't think we want judges to become mandatory reporters.
Okay.
Why not?
How can they remain objective and, disinterested if they're mandatory reporters subject to?
Right, they'd immediately have to recuse. And then you've delayed more.
Yeah, I don't think we should get into this part of it.
Okay. And not custody evaluators either, I guess.
Right.
They're mental health professionals, so they're mandatory reporters.
Michael,
and I'd argue that judges are too, because everybody in Maryland is a mandatory reporter.
Yeah, making a report is not the same as making a determination. I don't think it violates or crosses into any ethical territory, but
I can guarantee that any attorney who's doing their job, as soon as a judge reports to CPS and says, I have factual knowledge that there's been abuse, they're going to file a motion to recuse them from the case and say that they can no longer be objective. And so it may be true that as citizens of Maryland, they are mandatory reporters. So if they see the neighbor child at their home being abused by the father in that house, they are mandatory reporters just like the rest of us. But I really think you're treading on difficult ground to try and point a finger at judges in this recommendation and say, and you all have to report too, or else you're in trouble. Right. I mean, I just find that
I think we're
really beyond our.
I don't think.
All right, guys, we're let's go back to where we were. All right, we need to settle the language that we're talking about in this particular area. So can we just focus in on that and get that done?
Yeah.
Mr. Secretary, the siblings are fighting. The siblings are fighting.
Yes, I know. I got that.
Okay.
All right.
If I'm trying to do something very broadly, is it the recommendation to establish a process, which we could do through legislation and get more technical, but establish a process to ensure that before a child custody evaluator is appointed, any incident of disclosure or discovery of child abuse is reported to the appropriate authorities?
Okay.
Appointed is the operative word there, Jen, because you have to include ongoing evaluations that are ongoing. So just keep in mind, you have to include it to suspend or postpone or not appoint. There's some nuance there.
I missed the very first thing that you said before you.
There's some nuance, Jen. You have to make sure that you're covering custody evaluations that have already started, not just ones where you're preventing the appointment of.
Is appointed or admitted.
It sounds to me like we're just basically trying to, wherever the custody evaluation process is, stop it in its tracks as soon as there is some discovery or disclosure and kick it to the appropriate authorities. And I don't know. This is where you're better at the language than I am, Jen, but.
Well, apparently not, so.
Nobody said this was easy.
No, this is why we wanted them earlier. So establish a process to ensure that a custody evaluation does not begin or continue until any incident has been.
There you go. Yeah.
Or we can flip it around. Can we flip it around where we say that?
Hang on, let me get the one thing before.
Sorry.
Custody evaluation, it begins or continues. I mean, we can clean this up with legislation. Obviously, this is not what we would put in the code, but
yeah.
Okay.
I was just saying, if we say instead, we don't have to worry about where it is. If we start out by saying when there is a discovery or disclosure of abuse, that it is forwarded to the appropriate authorities prior to any continuation of a custody evaluation, wherever it may be. So that way we're not having to deal with what stage of the evaluation we're in. We're focusing on the first part of the process, which is it has to go to investigation by others.
Hey, everyone, my apologies. I have to jump off. I do have a standing meeting that I can't miss. So I think we're very close, though. Jen, I think you've got sort of the gist of what we're trying to accomplish, and you can work on the wording. My apologies. I have to jump off.
Thanks very much, Camille. Thanks for your help.
Thank you, Mr.
All right,
Thank
let
you,
me
Camille.
read it again. Establish a process to ensure that when there is an incident of disclosure or discovery of child abuse, scratch that.
Yeah.
You might have this too. Establish. It must be reported to the appropriate authorities prior to child.
The continuation of the
Yeah,
custody
that's the word.
evaluation.
Thank
Yeah.
you.
Something like that.
Or interference.
I think must be
Prior to the continuation of the custody evaluation process, that way, wherever it may be.
Establish a process to ensure that when there is an incident of disclosure or discovery of child abuse, it must be reported to the appropriate authorities prior to the continuation of the custody evaluator process.
Or prior to the initiation of or continuation. Trying to say.
Excuse me.
Initiation or continuation of the custody evaluation process.
Yes.
Okay. Sorry, and I'm having some technical issues, so I can't put this up on my screen, but establish.
Can you read? Yeah, can you just read it, Jen, please?
Sure. Establish a process to ensure that when there is an incident of disclosure or discovery of child abuse, it must be reported to the appropriate authorities prior to the initiation or continuation of the custody evaluation process.
I think that captures it. Okay.
Anyone? Okay.
Anyone else want to weigh in on that?
You sure you want to ask that question?
Probably not.
That's a loaded one.
Yeah, I
and
know.
then my thought, perhaps I could just put that. Would you prefer it as a separate recommendation, or to maybe squeeze it into recommendation 19, which talks about the uniform requirements for what custody evaluators are to do? I think the uniform requirement would basically be for them to pause in certain situations. So maybe we could just add it there.
That makes sense. What do you think?
Yeah, I think that covers it. That makes good sense.
And again, everybody needs to keep in mind that, we could talk about, the evaluators for an entire week, right?
Yeah.
So, that we're opening this huge can. So I want to make sure we stay focused that, we will be looking at legislation efforts, and this obviously is something that will be incorporated in that. So just keep that in mind. I know everybody's is nervous about, we didn't get this in, we didn't get that in. I just wanted to keep reiterating that this is not the end.
Okay. Anything else? Jen, are you comfortable with what you have now?
I think so. Heather, Jen Young, anything else?
I think you covered it.
Everything else? Okay.
Good job.
So we got through all the draft recommendations. There are a few little tweaks. We're increasing the hours, and that seemed to be it, correct?
Correct.
On my notes. And then the addition of the sentence we wrote after the last hour. So,
Right.
okay.
All right. Well, thank you, Jen, so much.
Thank you, everyone.
Taking us through all of this. So let me just say, finally, I want to say thank you to every one of the work group members for your hard work and dedication. And it's really been impressive. There's a lot of brain power and a lot of experience that you all brought to the table. And your depths of knowledge and experience has really been helpful to make this work. As I said, so this is our final meeting. And as has been said, this now is going to be given to the governor and the General Assembly, and hopefully we'll get some good legislation out of all of this. We're so pleased that we've had our senators and delegates that have been here participating in this, because I know they've learned a lot. I know I've learned a lot, and I think it's been time well spent, because this is a difficult issue. There's no question about it, and we're breaking new ground. So we will count on all of you being there to help support this when it comes before the legislature. And so I just want to say also one additional thing, and that is we do appreciate the commitment and the input that's been offered by protective parents, by the advocates, and by the attorneys who practice family law and who've attended so many of our meetings and listened in to these conferences that we've been doing on the air. That insight clearly has been invaluable to us in putting this work together, because you're the ones that have been really affected by all of this, and your children. And so it's clearly that assistance has really been valuable in helping us shape so many of these recommendations. So thank you so much, all of you. And we'll look forward to seeing you again in a different forum. But with that, I'm going to adjourn the meeting. Thank you very much.
Thank you.
Mr. Secretary, that's something. I'd just like to thank you, Mr. Secretary, for your outstanding exemplary leadership of this work group, because we are in ground zero. And I thank all the advocates too, and the leaders, because you are all the leading experts in this issue. And we're breaking ground, as the Secretary said. So I think we're going to still continue to meet. Mary Beth and I will be working very closely with you, hopefully again, because I think a lot came out of this work group. And there are a lot of things I learned about that we didn't know about before, about how complicated this is. And so I'm very honored to have had all the stakeholders here working together. You know, we may not have agreed on every single detail, but I think we got a lot done. And thank you for your leadership, Mr. Secretary, and also for Ann Hoyer and Brittany Laurie and all the staff. Thank you for everything that you do. And we don't know what's going to happen with the session because of COVID-19, but we'll still be working with you. Thank goodness we have Zoom. So anyway, again, my deepest gratitude to everyone, and particularly our wonderful Secretary John Wilkinson.
You're here.
Thank you so much.
Thank you for your leadership, Mr. Secretary.
Senator Lee, I just want to say something to you. We wouldn't have this work group unless you sponsored it. And, you know, as we talked about this in the beginning, and your commitment to this and you wanting to learn more about this, kudos to you, my friend. Thank you so much, Senator, for spearheading this.
And Mr. Secretary, just to add, I really appreciated Senator Lee's remarks, and thanking your leadership, the whole team. You know, when you think about what we're experiencing with COVID-19, and I am very proud that this is among the most important work, you know, given everything that's going on, that we are staying focused on protecting children in this process. And, you know, all the expertise with this work group and the recommendations and the suggestions, my takeaway is the complete commitment to protecting children in this process. And so I'm proud of the work that we have done together. And I know that we can take these recommendations and take it to the next step. And I vow to this group to continue to work with all of you so that we can continue to make progress in the next session.
Thank you, Senator.
Thank you, Senator Carruthers. Thank you all. Safe travels.
Thank you. Be safe, everyone. Stay healthy.
Bye-bye.
Bye.
Heather?